afternoon, Your Honors.
Afternoon.
May it please the Court, my name is Joseph Ronderas, and I'm happily here representing Appellant Momentum 3, LLC. I would like to reserve 3 minutes for rebuttal.
All right, sir, you may proceed.
All right. Your Honors, this case involves a default judgment obtained by plaintiff and appellee Dixon Management against the wrong mortgagee on property located down in Shelbyville. Despite being the wrong party, that judgment and the subsequent orders of the trial court threatened the property rights of my client, which was assigned the deed of trust and stood in the shoes of the correct mortgagee. We're here today because the trial court denied my client's motion to intervene to protect its rights and the property under the deed of trust. And I know Your Honors have read the briefing in this case, but I'll very briefly go over the background because I think it's important to understand the timing of issues and understand how we got to this point and clarify who the true mortgagee is under the deed of trust and who should have been named to Dixon's suit to begin with. This case originated as a suit in 2023 where Dixon sued for unpaid water mitigation services that it performed on the property in response to pipes that burst during a winter freeze in December and November of 2022. Yes, sir. And Dixon filed a notice of lien, would later amend the complaint and add what it believed to be the lender under the original deed of trust, naming Webster Financial Corporation as the successor to Sterling National Bank. The problem, of course, is that Webster Financial Corporation was not the successor to Sterling National Bank, who was the original lender under the deed of trust.
Is Webster Financial the parent of Webster Bank?
Yes, Your Honor. They are the holding company and the parent. But despite the two sharing the name Webster and the same name, they are distinct entities and should be treated as such. When the case was brought against Webster Financial failed to respond. Dixon moved for a default judgment and secured a default judgment that said Dixon's lien for its services it had priority over any interest, not just of Webster Financial, but of any other interest, including deeds of trust on the property. And of course, therein lies the problem for Webster Bank, and then later on, Momentum, my client. Webster Bank, the true mortgagee at the time of these judgments, was never made a party to the case. And when it went on to assign the deed of trust to Momentum in May of 2024, it has still not been made a party to this case. On August 27th of 2024, Momentum first learned of this sheriff's sale that Dixon had initiated to enforce its judgment against Webster Financial. And at that time, it decided to move to intervene, knowing that this sheriff's sale would necessarily impact its property rights. And it did so on September 12th of 24, less than 30 days after knowing of this suit. As part of those proceedings, Momentum argued that it was the true mortgagee, that it was the real party in interest. It laid out the knowledge that it had and when it moved to intervene. In response, Dixon argued that you no longer have standing. That is because our judgment lien has priority over your deed of trust. The trial court denied Momentum's intervention, stating Momentum had record notice of the judgment lien at the time it received and recorded the judgment and does not have a right to intervene at this juncture. And also that Momentum is not the real party in interest and cannot challenge the judgment or the sheriff's sale. Now, Your Honor, I know that there's
Do we know when Webster Bank and Momentum entered into negotiations about the assignment of the loan and deed of trust?
That's not in the record, Your Honor, but I know that the assignment, and as Dixon will point out, it's in their brief, that Momentum was formed in the same month that it acquired the assignment. Not to say that there's anything wrong with that, because of course special purpose vehicles are always made for big commercial purchases of multi-million-dollar loans and property interests. But as the record will reflect, is that there's simply an assignment made in May of '24.
Is there any connection between the two entities?
Between Webster Bank
And
and Momentum, no, Your Honor, but of course that's also not precisely, I guess, stated in the record, but it certainly doesn't come up in the record.
Counsel, in terms of thinking about a motion to intervene, and thinking about the standard, a lot of the argumentation in this case seems to focus on what actually is rather than what is alleged. In thinking about a motion to intervene, is this essentially tantamount to a motion to dismiss standard where it's not whether it's true or not, it's what's alleged in the motion that the court should be considering in deciding whether to allow a party to intervene?
I think it's a little bit of both, Your Honor. It's not quite the motion to dismiss standard, but there is an element to intervention that is a substantial legal interest that's required to intervene is a claimed legal interest.
Isn't the claim of an interest rather than, I mean, the language of Rule 24, right? It's a claim. And that sounds to me like it's an assertion or an allegation rather than necessary. And you could not have a property interest. You'd be entirely wrong here. And the trial court, though, in determining whether to allow intervention, does it need to look at it through that framework of the claim that's being asserted?
Your Honor, I think you're stating it accurately. I just don't know if I would compare it to necessarily a motion to dismiss standard, but it is a claim. It's an assertion of a legal right in the property, and I don't think the trial court needs to get beyond that necessarily to evaluate whether this judgment lien actually has priority over the deed of trust at that time. We, of course, maintain that the deed of trust had first priority because the assignee stands in the shoes of the assignor, and it predated the judgment lien.
If you're wrong about that, do you still have an interest in the property?
Yes, Your Honor. Yes, we have a first priority deed of trust. I think that is pretty clearly established by black letter case law that assignments, the assignee stands in the shoes of the assignor. The deed of trust predated the judgment lien. The fact that a judgment lien is recorded and then an assignment is recorded afterwards does not deprioritize the deed of trust that predated it. And I think that's part of our argument, of course, is that we need to intervene to get rid of an order that is contravention of the law that we claim is void for both procedurally and substantively, in the sense that you can't declare a judgment lien that comes in later after a deed of trust to be superior to a first deed of trust, but also the fact that Momentum was never served, never made a party to it. We think those orders are void. But when we make those arguments, we're making the argument that would, after intervention is permitted, we would raise in a motion practice.
Could you also file a separate cause of action seeking to determine that the judgment entered here was void or voidable?
We could, Your Honor. I think that the risk there is that the voidable versus void distinction that you touched upon, if the judgment is merely voidable, you can't bring a collateral attack on that judgment. And as we've demonstrated throughout the trial record, we have introduced records to show that.
So it's not, you can't tell on the judgment's face, so therefore it's at best case. I mean, I'm not committing you to that position here, but you need something on the judgment's face in order to determine it's void.
Yes, Your Honor. That's generally what Turner v. Turner says by the Supreme Court. I will say that we maintain that the judgment is void, but the reason we need to intervene is protect against the outcome that the judgment may be merely voidable, because there is additional evidence that we have produced showing that Momentum was the proper party. Webster Bank before it was the proper party to this case.
Is it necessary for this court to determine if the proper original holder of the deed of trust was served in this action?
I don't necessarily think so, in the sense that that would go to whether the judgment is void, which I think is something that would then be later determined.
Well,
I think
if we were to determine that the proper holder of the deed of trust was not served correctly, would that necessarily allow your claim for intervention?
I believe so, Your Honor, yes. I just don't know that it's necessary because, of course, the fact that the naming of the wrong party at the outset of the suit, I think very clearly states that even with purported service on Webster Financial, that just isn't sufficient, Your Honor. Very briefly on the timeliness elements of this, we do cite to the American Materials case regarding the timeliness elements, and I think the biggest issue that we've addressed in our briefing is that this necessarily comes post-judgment. Part of our argument is that if the judgment is void, that there really isn't a judgment that can preclude intervention after a judgment that's void has been entered. There's also the elements of prejudice, purpose of intervention, length of time. I think we've established that length of time was within 30 days of being aware of it. Prejudice to the original parties. Dixon cannot claim any additional prejudice from having to relitigate against Momentum as the true mortgagee because it should have been named, or Webster Bank should have been named at the outset, and Dixon failed to do so. As far as the purpose, again, we're addressing a void judgment that purports to impair our property rights, and for those reasons, Your Honor, we don't think that our intervention was untimely. We would ask that you reverse the trial court's decision, vacate the order denying the motion to intervene, and instruct for Momentum to be allowed to intervene. So, thank you, and that's all my time.
Good afternoon, Your Honors. My name is Jay Wallace-Irvin with the firm of Lewis Thomason here in Nashville, on behalf of the plaintiff in the appellee Dixon Management Group, LLC. Your Honors, I want to first clarify a few things. In terms of the statement of the issues that the appellant had provided, there's narrative there, but and then three specific points. The first statement of the issue was that Momentum, did the trial court err when denying Momentum its right to intervene, finding it was not a real party in interest, to challenge the judgment and execution via the sheriff's sale? The second is, did the trial court abuse its discretion when finding Momentum could not intervene at this juncture? And the third was, did the trial court err denying Momentum's alternative relief for joinder as a necessary party as the assignee of a first deed of trust? Your Honors, I raise that because there are several points kind of working backwards from the briefing that I wanted to bring up. One, in terms of joinder, the motion that was made at the trial court was for two purposes. One, to challenge the underlying judgment, and then the second was to challenge or delay the sheriff's sale that was ongoing to enforce that judgment. As it stands right now, one, I'm not aware of any ruling by this court or the Tennessee Supreme Court allowing joinder under Rule 19 after the entry of a judgment. I had looked, I couldn't find one. And I think that the fact that it's basically summarily addressed in the appellant's briefing acknowledges that fact. The second is in terms of the sheriff's sale, to the extent, regardless of whether it's under Rule 24 or under Rule 19, the sheriff's sale did not occur. There was no sale. So to the extent that the motion attempted to seek a delay or otherwise challenge the sheriff's sale, I would respectfully submit that that issue is moot at this point, which leaves us, and I'm going to focus my argument on the remaining issue, which is a question of whether or not the trial court erred in denying intervention under Rule 24 of the Rules of Civil Procedure. Now, my colleague gave you a little bit of history in terms of the facts. This is not a factually complex case, but I do think we need to add a couple more facts to that in terms of the timeline. The first is in terms of the underlying deed of trust that's at issue in this case. It was issued in favor of a lending institution known as Sterling National Bank back in 2022. At the time, that was the second deed of trust on the property after the Greystone servicing deed of trust. Greystone, being the initial lien holder, was named first. After the suit was filed, they provided notice that that had been paid off, and that the only remaining deed of trust was the Sterling National Bank deed of trust. At that point, the amendment was made, and notice was provided and served in accordance with the Tennessee Rules of Civil Procedure on the bank's president. At the time, it was Sterling National Bank. That bank merged with Webster Bank, as did their parent company, Sterling National Association and Webster Financial Corporation. The
But you're
president.
saying they weren't separate entities, they were all one entity?
No, Your Honor. They were separate entities.
Okay.
The parent corporations both merged, and according to their website, created one of the larger national banks in that area. There are typically, when there is a bank merger, those mergers are noticed in the register or recorded in the Register of Deeds office. At the time this suit was filed, there was no notice that had been recorded in relation to any assignments of deed of trust, assignments of financing statements or other UCC documents, and certainly no notice of the merger between the banks themselves. There was a notice that was later filed in January of 2024 after the entry of judgment. So in doing due diligence, the matter came to be known that Sterling Bank had merged. According to the information that was available on their website, which is in the transcript, it noted that the two parent corporations merged, and so we served the president of the bank, Webster Bank, who is also the president of Webster Financial Corporation. So
That's who you served initially?
yes, well, in terms of the bank, yes, that's the only service that has been made in this case.
And at this time, what had happened to Sterling?
Sterling Bank merged into and was the non-surviving entity of the.
At the time of the commencement of the lawsuit, had Sterling merged?
Yes, Your Honor.
Okay.
Notice had not been recorded, though, at that time in the Register of Deeds office. So the only records.
Well, okay. Isn't that problematic?
No, because Webster that we've used the terms or seen the terms successor in interest in these pleadings. Webster Financial is the successor in interest to Sterling and would have been the surviving entity. So notice on Webster, although it had not been recorded, with Tennessee being a race notice state, they still would have, as between the two entities, Webster would have been the real party in interest. Had
the merger actually been accomplished by the time you filed the lawsuit?
Yes. The merger had been effected, I believe, in February of 2022.
So you're saying that service on Webster Financial was good for Webster Bank? Is that your position?
At the time that, yes, is the short answer.
Okay.
But at the time, the only information that was available was on the Webster Bank website, which identified Webster Financial as being the entity that was assuming all of Sterling National Bank. So in terms of service was made, a return was made, the service was through certified mail, green card was signed off on, and the lawsuit moved forward in terms of the motion for default.
Counsel, I want to ask you the same question I asked opposing counsel, which is the standard here that we should be using in assessing this. And
Sure.
So Rule 24 speaks of a claim.
It does.
Is this, in reading the briefing, there's a lot of what is rather than what is alleged.
Correct.
In terms of a trial court thinking about these questions, is the right way to think about it applying something akin to like a motion to dismiss standard where you're looking at what's being alleged with regard to making a determination as to whether allow intervention, or is this something where the trial court should go more into what actually is?
I think in this scenario, this is and specific to this, because Rule 24 deals with motions to intervene in total. We are very specifically after the fact here, which is a unique circumstance post-judgment. If, to your point, if the question is, but I don't know that it matters. In terms of motion to dismiss standard, to me that is much too lax and gives too much leeway and basically opens the door. And it's more of, if as long as I can make a claim, I automatically get to intervene. The court has to have some gatekeeping function to me in that regard, particularly here post-judgment. as far as I'm aware, there's not a case in Tennessee that discusses the standard of review that you would utilize in a situation like this. To me, if I was sitting in your shoes, it would be at a minimum a shifting burden where somebody has to show that they basically have a prima facie case, to be able to meet that burden. Here, if, the allegation that the appellant has taken is that they want to try and challenge the judgment, which would mean they have to show there's some defect there. At this point, there's nothing in the record that would show that it's a void judgment. The only thing they rely on is an affidavit that they presented to the trial court in support of their motion, where it said the individual who signed the green card was not an employee. There is no statement in the record that the individual who signed the green card was not authorized to accept service, and that is an important distinction, because I myself serve as a registered agent for several corporations, although I'm not an employee of those corporations. The other is in terms of the primary issue here is, regardless of what standard you utilize, the trial court here found that the motion was not timely. And so before you ever get to the questions of what would the standard be in terms of the basis for the motion is whether or not there's a timely motion, and that's based off
timeliness in the Rule 24 context. You would say timeliness in terms of the overall state of the litigation that you're trying to intervene in. It doesn't refer to the time that your interest was acquired.
I would agree with that. At this point, it's post-judgment for the purpose of the exercise of this court, because it's a unique exercise. I can understand the varying viewpoints of it. We decided to provide notice that, as far as momentum is concerned, that within 4 months of obtaining an assignment, we filed a motion to intervene. The problem is when you get into the various factors in terms of whether or not Rule 24 allows for that intervention. One is unique circumstances, number 5, and that is in terms of the timing of when the negotiations happened, to your question earlier. The momentum did not exist until May 20th of 2024. It took an assignment on May 21st of 2024, and that assignment was recorded on May 23rd of 2024. So in terms of the entity itself, it could not have had negotiations more than a day before. Now, could its individual members have had negotiations beforehand? Sure, but that's not in the record. Now, back to your point about, or question about the standard of review. Again, I think at a minimum it's a shifting burden. Some, momentum would be required to show somehow that it would be void before they could even go any further. But that's only one aspect of the factors that we look for. The court here found that they had prior knowledge that they were not the real party in interest because they took a non-recourse assignment of a deed of trust. Throughout the pleadings and through the argument today, there's been the statement that momentum was a first priority deed holder. They were not. As we stand here today, there is a valid judgment as far as this proceeding is concerned. That is a final judgment that said that the lien, the mechanics lien, which is where this began, was a valid and enforceable lien, that lien, based on the motion that was presented before the court, took priority over the deed of trust that was in place with Webster due to its default and other aspects of the case. And from that point forward, when it was recorded, the judgment lien reflected that lien and its priority over the deed of trust. The question is not whether the judgment lien granted priority over the deed of trust, but whether the trial court's order in finding that the lien took priority and the lien and the subsequent judgment lien took priority over that deed of trust. So that deed of trust, or the judgment was entered in June of 2023. The judgment was recorded and served as a judgment lien to provide notice to everybody, not just the parties, in August of 2023. You go another 9 months before you get to momentum even being created. So when it talks about its legal interest and its interest in the property, the other is, could its interest have been properly defended or represented in the pleadings? We have to go back and look at what its interest actually is. When they took the non-recourse assignment, they took only, as counsel said earlier, only what Webster had at the time. And at the time that it took the assignment, it had a it had a deed of trust against the property that was junior to the judgment that my client had.
So but that all is dependent on us agreeing that the judgment is a valid judgment.
Well, and again, I don't know that that question is before the court. It's simply whether or not Momentum has standing to intervene in this case. And so it's a little bit of a cart before the horse, and candidly, I can appreciate where the court's coming from, because if it was a void judgment, there would be concern there. But then that goes to the court's ruling that Momentum was not the proper party. This is not a situation where we have a party that no longer exists. Webster Bank is still in existence today. Their counsel has been copied on pleadings before this court and the trial court below, and there is evidence in the record where Webster Bank actually submitted letters to me in response to the pleadings that we were sending them at the time. So to the extent that any party wanted to challenge the judgment, that party would be Webster Bank, not Momentum. Which is why there's a number of things going on here in terms of the.
So, well, part of your argument here is the fact that because Momentum's position as junior or subordinate to your client's interest, that is not a substantial interest for purposes of intervention.
Correct.
So does that rule work, in other cases as well? So if I have, two deeds of trust on a property, the second the beneficiary under the second deed of trust couldn't intervene in a case like this?
So to address your question, I'm going to talk quick. We are post-judgment at this point, and so when there are multiple lien holders, whether they are judgment liens, whether it's deed of trust, or lien lease pendants for that matter, as a party who is executing on a judgment, whether they be the first priority lien holder or the third priority lien holder, they are the one who is driving the bus in terms of moving the execution sale forward. When the sheriff's sale actually, if it had actually gone off, the party's interest, regardless of where they stand in that line of priority, their interest is in the proceeds.
Right, and so, there was a potential buyer that came in after the sheriff's sale. I know the court did not approve.
Correct.
For that transaction, but at the valuation placed by that buyer, there would be some recovery from Momentum, would there not? After payment of property taxes, $200,000 property taxes, your client's $344,000, $700,000 potential purchase. That seems to leave some money over for Momentum.
Correct, and at that point, the obligation is on the sheriff's department to determine which parties are entitled to the excess proceeds, but it's in the excess proceeds, not the property.
Okay.
Thank you, Your Honors.
Your Honors, I think the non-recourse theory that's been advanced in response to this appeal is fundamentally flawed. And I think part of the reason is that you can't just ignore corporate separateness and lump the subsidiary and the parent together. The fact that the parent was named in a suit and not the actual mortgagee, I think is fatal to that argument. There cannot be a...
Let me pose a question to you. Why are you not limited by whatever rights Webster has here? Because you took an assignment from Webster, correct?
That's correct, Your Honor, and I would...
So if Webster had knowledge and Webster was defaulted and did not defend, why would you be in any better position than Webster would be at this point in time?
And, Your Honor, I think there's a misunderstanding as to the Webster that got defaulted. Webster Financial was defaulted. Webster Bank...
Well, what you're saying, or what I'm hearing, and perhaps I'm hearing it incorrectly, is we don't get to that issue today. The only question we're really looking at is whether you have a right to intervene. So we have to take the facts as they exist.
Yes, Your Honor, and I'll admit that, back to Judge Usman's comment and questions, that and what counsel talked about is that there is a bit of circular reasoning, cart before the horse, however you want to put it, that is involved in this, because there is a claim that is being made, to Judge Usman's point, to the property. And if we stop there, then of course I think that it moots a lot of the arguments about whether it's void or not, because that's going to be decided after intervention is permitted. But we also are asserting that by virtue of this judgment being void, it cannot affect the interest of a deed of trust that was properly assigned by someone who was never a party to this case.
But according to what I'm hearing both of you say is we don't get into the question of whether the judgment's void. That's for the trial court to decide another day if you're allowed to intervene.
And yes, Your Honor, that may be the ultimate result of this case. I will say that because we do claim a legal interest and show a substantial property interest, that necessarily gets into whether there is a judgment lien that has priority over an interest that was never named.
But what are you claiming, as Judge McBrayer just pointed out, that perhaps there are excess proceeds because following that logic, Webster's been representing you throughout, even though Webster represented you by being defaulted?
And Your Honor, there hasn't been adequate representation because Webster Financial is not the same as Webster Bank. It doesn't have an interest in the property. Well, Your Honor, I think there has to be some discussion of that because you have to determine who the appropriate parties are to the case, regardless of whether we're looking at whether the judgment is void or voidable. It's a matter of who is the true mortgagee in this case. And in order to determine what intervention rights there are, you have to determine whether Webster Bank was the true mortgagee. And I think that has sufficiently been established by the record.
A timeline question. Sterling's interest is recorded, right? Now, it's not recorded in Webster's name initially. It's recorded in Sterling's.
Yes, Your Honor.
Sterling, we end up with a merger. Wesley Financial's the survivor entity out of all of that. There's not a recorded interest in Webster Bank's name at the time the suit is filed, right? The recorded interest, if I go down, I'm looking through, I'm going to see Sterling Bank at that point, right?
You will see Sterling National Bank, which is distinct from. I just want to make this clarification, which is distinct from Sterling Bank Corp,
Okay,
which is the entity that survived the merger that counsel has talked about.
All right, Sterling. So the recorded interest is going to say Sterling National.
Yes, Your Honor.
Which Sterling National is going to become part of Wesley Financial here. And at the date of filing, there is no recorded interest that is in Webster Bank's name, right? Instead, I'm going to go see, I go and look, and it's going to say Sterling National. And then I look and I say, well, Sterling National is now part of Wesley Financial. And so I go and serve Wesley Financial. So on the date of filing, there's nothing to tell the opposing party here that Webster Bank is going to be the successor bank that's taking this interest, right? On the date of filing itself. Or am I wrong about that?
I agree that there's nothing in the recorded, in the registrar's office that would suggest anyone other than Sterling National Bank. The issue is twofold. The party that was named was Webster Financial Corporation, FKA Sterling National Bank. There might be a different outcome in this case from our perspective if Sterling National Bank had been sued, because Sterling National Bank merged into Webster Bank National Association. The national
Did Sterling National Bank exist anymore as a separate entity on the date of filing?
It did not exist. Sterling National Bank did not exist. The merger happened in February of 2022, I believe, before the filing.
They were supposed to serve an entity that didn't exist anymore?
Your Honor, if they had served an entity that didn't exist under the registrar's office or the National Bank Act, which is a separate registration service, they're not registered locally. If you had gone through the National Bank Act, I speculate a little bit that you would find that Webster Bank was the national bank that succeeded to Sterling National Bank. What happened was.
So these are both national banks?
Yes, Your Honor. They're both national banks, so they're not usually recorded on a local, or excuse me, registered on a local level. So when you go to the registrar's office,
But even for national banks, the better policy is when you assign a deed of trust, you record an assignment.
yes, Your Honor, and the assignment was recorded. What wasn't recorded,
Yeah, there wasn't a assignment recording, transferring the deed of trust from Sterling to Webster Bank, or even changing the name.
there was
Which I
not.
suspect is part of the reason why was over $200,000 of unpaid real property taxes here. I'm guessing that those property tax notices went to the entity that no longer existed.
I can't speak to that, but what I will say is that, and I just want to make sure that it's clear the dynamic here. Webster Financial is a parent corporation. It's a holding company. It merged into Sterling Bancorp, another parent company, or excuse me, Sterling Bancorp merged into Webster Financial, another parent company of the bank. The banks merged into each other, Sterling into Webster Bank. So the fact that there's a defendant that's named parent company, formerly known as subsidiary, that had no merger between the two, I think is another just fatal flaw. And I think what this ultimately presents is a fundamental issue of due process, certainly touches upon the lack of notice and opportunity to be heard, Your Honor. And that's why we'd ask you to reverse and vacate. So.
All right, counsel, thank you for your argument. We will take this matter under advisement and attempt to get you an opinion at the earliest possible time. That concludes the call of the docket for today. We'll stand in recess to the call of the docket by the presiding judge.